Good afternoon, stakeholders. For those of you that I have not had the opportunity to meet or work with, I am Lori Law, the Salem District Civil Rights Manager. You will also be hearing from my assistant, Miss Brianna Hatcher. Salem Civil Rights is excited to provide an update to your questions regarding good faith efforts, along with showcasing information on our new civil rights labor management system. This system is web-based and it will provide us with a faster, easier, and more accurate way to manage the agency's labor, EEO, and DBE regulation reporting requirements. Be on the lookout for future training opportunities from the Salem Civil Rights team. Now I will turn it over to Ms. Brianna Hatcher.
Thank you, Lori, for that introduction. Today we are going to be giving an update on the bidding process for local projects and provide guidance on good faith efforts. First up, pre-bid meetings. Salem Civil Rights attends the pre-bid meetings that are held by the locality. During these meetings, we discuss civil rights requirements and good faith efforts. One of the points we like to emphasize is ensuring bidders are reaching out to DBE certified firms to obtain the contract DBE goal. SWAM firms do not count towards this goal, and this can result in a non-responsive bid. We also encourage stakeholders to utilize the Virginia Small Business and Supplier Diversity website to locate DBE firms, validate if a firm is DBE certified, and to check if the DBE firm has the correct NACIS codes for the type of work being solicited. You should always make sure the firm is certified in that type of work. There are two examples shown on the screen. The first is for Glade Construction, which is a SWAM firm. You can see their certification type and the start and expiration dates of that certification. The second example is LAS Trucking and Construction, which is both a SWAM and DBE firm. Once again, you can see the SWAM certification information in the blue and the DBE information is listed in the green. Note that LAS has a NACIS code that covers the traffic control, indicating that they are certified to do that type of work. DBE solicitations. It is important to exhaust every effort to obtain the contract DBE goal. Some of these efforts can include breaking out contract work items to facilitate DBE participation. This means looking at all items of work, not just the items the prime bidder wants to subcontract out. It's encouraged that bidders reach out to multiple firms per items of work. Do not stop at one firm. The prime bidder should also determine with certainty if the DBE firm is interested. This involves taking appropriate steps to follow up with the firm and not just the initial solicitation. When soliciting, the bidder should reach out to the DBE firm no less than 5 business days before the bid's due date. Failing to do so can result in a non-responsive bid. Another thing for prime bidders to make efforts on is assisting the DBE firm with obtaining any bonding, lines of credit, insurance, supplies, or materials needed for the project. On top of reaching out to firms directly, the bidder should also solicit through pre-bid meetings or advertisements in a newspaper of general circulation. We encourage firms to document their efforts in obtaining the DBE firms. This includes, but is not limited to, maintaining a telephone log and internet contacts. Once the bids have been submitted, they are reviewed by the locality and civil rights. 49 CFR Part 26 requires VDOT to collect certain data about firms attempting to participate in federally assisted contracts. Form C-48, subcontract/supplier solicitation and utilization, must be received within 10 days from the bid opening. Additionally, a firm data sheet is required for both professional and non-professional service contracts. If a bidder is unable to meet or exceed the contract DBE goal, they should submit within 2 days from the bid opening Form C-111 showing the DBE participation the firm is committing to attain, and Form C-49 summarizing the good faith efforts made. The lowest and responsible bidder should submit Form C-112 within 3 business days after the bid is received. According to VDOT Special Provision 107.15, a bid may be rejected if the bidding firm fails to submit the required documentation within the time frame specified. The locality will first assess the bid and make a fair and reasonable judgment whether a bidder that did not meet or exceed the DBE goal made adequate good faith efforts to obtain that goal. Once the locality has decided if the prime bidder either did or did not make good faith efforts, civil rights reviews the locality's determination and either concurs or does not concur with the locality's decision. This decision is done in accordance with 49 CFR 26.53, 49 CFR 26 Appendix A, and VDOT Special Provision 107.15. If civil rights determines that the locality's decision is not in accordance with the aforementioned regulations, they will then provide technical assistance to the locality. If the locality finds that the firm made adequate good faith efforts, but civil rights does not concur, finding that the bidder did not make good faith efforts in accordance with the regulations, the locality may still choose to proceed with the award of the contract. However, civil rights will move forward with recommending non-reimbursement of federal funds. So what determines a responsive bid? When bidding on federally assisted projects, good faith efforts are required when trying to meet the contract DBE goal. This is applicable even when the prime bidder is a DBE firm. The bidder must submit the names of the DBE firms that will be utilized, and they should show that they took all necessary and reasonable steps to achieve the contract goal. This is where documenting is very important. If the bidder was unable to reach the DBE goal, then they will need to provide this documentation to the locality using Form C-49. When looking at the documentation, the locality should determine if the bidder employed efforts that one could reasonably expect any bidder to take if they were actively and aggressively trying to obtain the DBE participation sufficient to meet the DBE goal. When reviewing the documentation provided, the locality will look at the quality, quantity, and intensity of the effort the apparent bidder has made. These efforts can include documenting solicitation efforts, for example, emails, phone calls, attending pre-bid meetings, or the use of advertisements in newspapers, follow up on solicitations, and documenting when DBE firms are not able to participate. The locality should take into consideration if a DBE firm provides a quote that is excessive or unreasonable compared to standard industry rate. Note that the performance of other bidders in meeting the contract DBE goal can be a relevant factor when the locality is determining good faith efforts. The example on the screen discusses a scenario where the apparent lowest bidder failed to meet the DBE goal, but all other firms were successful. In this instance, the locality may determine that the apparent lowest bidder, with additional reasonable efforts, could have made the DBE contract goal. If the initial review by the locality determines the bid was non-responsive, this means that the firm failed to obtain the DBE goal and the firm did not adequately document that it made good faith efforts to achieve sufficient DBE participation. When this happens, the locality must provide the bidder an opportunity for administrative reconsideration in accordance with 49 CFR Part 26.53. If the apparent low bidder wants to proceed with the reconsideration, they should submit in writing within 5 business days of notification from the locality that the initial good faith efforts were not demonstrated. This request should be submitted to the project engineer. If the apparent lowest bidder chooses to take it to administrative reconsideration panel, the locality will need to compile the panel hearing file. This file should consist of bid documents received at the time of the bid. These forms include C-111, C-112, C-48, C-49, and copies of the request for bid solicitations to the DBE firms. This file will then be distributed to the administrative reconsideration panel hearing members for review before the hearing. The panel members are to be appointed by the locality and shall consist of a presiding officer and at least 3 voting members, one of which will be a representative from the VDOT Civil Rights Division. The decision of the panel will be determined by majority vote. In the case of a tie, the chairman shall cast the tie-breaking vote. Otherwise, the chairman will not vote. Once the locality has determined the members of the hearing panel, they shall notify the bidder as to the time, date, and place of the panel hearing. The bidder may be represented by counsel of their choosing. Preceding the opening statement by the bidder, an oath shall be administered by a court stenographer. The opening statement shall contain all matters which the respondent or bidder believes are worthy of the panel's consideration for good faith efforts. The locality may have counsel present during the panel hearing and any deliberations. Once the panel has voted, it should render its decision within 7 days from the close of the hearing. Please note that the decision is administratively final. Additionally, the panel shall provide to the bidder within 10 days of the panel's decision a written opinion regarding the basis for its decision. If the panel finds that the bid is non-responsive, the project should be awarded to the next lowest responsive and responsible bidder, if applicable. So now that we've gone over good faith efforts, I'd like to talk a little bit about our civil rights and labor program. There is a lot of helpful information found on the Outside VDOT webpage for the CRL program. You can navigate to the Outside VDOT website by Googling vdot.virginia.gov. From the home page, you're going to want to click on the Business Center link found at the top. Scrolling down under Things to Know, you're going to want to click on Ashtware Project Civil Rights and Labor CRL Management System. This web page covers the CRL system on the Outside VDOT website, and it has a lot of useful information about the system. For example, almost all contracts advertised after March 1st, 2020 that have federal funding will have the CRL special provision. Note that there are a couple of exceptions to this, but for the most part, all contracts that are federally funded will have this special provision. It also lets you know who will be required to use the system. All prime contractors and subcontractors working on VDOT projects with federal funding will be required to use the system to submit certified payrolls. Prime contractors will also be required to enter subcontract payments into the system. For our locally administered projects, a representative will also need access to the system to approve or reject submitted payrolls and ensure subcontract payments are being entered correctly. It also lets you know what you need to know about the system. The system is web-based and it can be accessed from anywhere. Note that when accessing the system, make sure you're using Internet Explorer 9, 10, 11, or Google Chrome. You still may be able to access the system using a different web browser. However, the full functionality of the system might not work. So just note that. So what do you do if you don't have access to the system right now? Your first step is going to be to download and complete the CRL, Access, and IT security forms. Once you download this form, you're going to get something like this. For this first page, you don't need to fill this out if you're submitting a request as a user that is going to be approving or rejecting payrolls. This is solely for the contractors that are submitting for the system. You will, however, want to fill out Form ITD 35E, as well as the second page of that form. Once you have that form filled out, you're going to want to submit it to the crlms@vdot.virginia.gov email address. After you submit, you will receive a series of emails letting you know your request is moving through the process. You do not need to take any actions on these emails with the exception of the email that contains your user ID and a link to the CRL system. Make sure you log in as soon as possible and change your password. Once you are in the system and active, make sure you sign in regularly every 3 weeks. If you do not, your user status will be changed from active to inactive. If this happens, you will need to email the crlms@vdot.virginia.gov email address, asking them to change your status back to active. There are also some training modules on the website that are geared towards the contractor's role in CRL. However, we do recommend anyone approving or rejecting payrolls go through these modules independently or attend a training session held by Salem Civil Rights or another district, as these training modules can be very helpful with your ability to approve and reject payrolls. You can also find some helpful PDFs on the website. I do like to recommend that all CRL users download and have handy the non-agency training guide, as well as the non-agency user guide PDF. Thank you all for letting us give an update on good faith efforts and the CRL system. If you have any questions, please reach out to myself or Lori Law. Our contact information is on the screen. Have a great day.